Good afternoon, everyone. Our webinar will start in a minute, waiting for the last participants. So good afternoon, everyone, and many thanks for sharing your time with us in the middle of this hot day if you're based in Western Europe. My name is Antoine Jouet. I'm a partner at Fidal, which is a French full-service law firm, and I'm based in Lyon. It's a real pleasure to welcome you to our fifth unyer webinar dedicated today to transparency. We'll try to cool down the temperature, at least on this matter. We'll have 1 hour together and we'll do our best to stick to the timing. Do not hesitate to use the Q&A tool to raise questions at any time. We'll do the maximum to answer during or at the end of the webinar during a Q&A session, which I believe will be sufficient if we remain some time. So thank you again, everyone, and I'm happy to answer your questions if you have. So what is unyer? A few words. We are a global organization of leading international professional services firms, with an exclusive approach accepting only one member firm from each jurisdiction. So unyer itself is not a law firm, but a network currently made of 4 law firms, namely Luther in Germany, Fidal in France, Pirola Penutosei in Italy, and KWR in Austria. This is an original model network, as each firm remains independent with its brands, clients, and services. It represents a high turnover and over 2,000 lawyers and advisors in more than 14 countries, as each firm has its own presence and network. Today, we also have the chance to welcome best friends in other countries, such as in Sweden and in Poland, with our esteemed colleagues from Max and SKS. In a global world, clients need global solutions. So this is why at unyer we believe legal firms must offer more than legal services for full service business, such as contract, commercial law, tax, IPIT, litigations, advisory solutions, notary in some countries, etc. So this is why we are here. And today we will mainly focus on employment law. During our previous webinars, we focused on employment aspects of whistleblowing and international inquiries, but also on new forms of employment, freelancing in international contexts. What are we talking about today? We will talk about transparency, and more precisely, pay transparency. Why? You may have heard that EU has adopted a directive dated May 10, 2023. So this is more than 3 years ago. And each state members is supposed to bring into force the laws, regulation, and administrative provisions necessary to comply with the directive by June the 7th of this year, so 2026. So the timing of our webinar was somehow perfect. However, over 27 countries, only 3 have implemented the final legislation, and for 2 of them, the legislation is only partial. So some countries even announced a postponement of the legislation, and some state members simply did not start to draft a legislation on transparency. We still believe it's important to discuss and to address this point today, at least this year, because even if the legislation might be, the entry into force of the legislation may be postponed, you will probably realize today with our participants and presenters that transparency is an immediate obligation. By the way, transparency, is it equal pay for employees? Is it just a transparency matter? Probably not. you may know that equal pay for men and women principle is an old principle in EU. So at first glance, you would say nothing new. But we still have a gender pay gap which persists. It was 13% in 2020, of course, with significant variations across member states, but it has decreased only minimally over the last years. So during COVID, the pandemic, we saw a disproportionately negative impact on women and on gender equality. So lack of transparency about pay levels has been viewed as a way to maintain situation. So why promoting transparency? I believe the answer is in the question. As you will promote transparency, it will reveal pay gap between genders. So this is a way of promoting equality. Please remember that all employees and employers are involved, public, private, workers. Also, it works for applicants, it works for part-time employees, so it's still very important. We believe that not covering these aspects, and this is not only us, but discrimination, it will reveal discrimination, so violations that could trigger litigations, possibly through class actions, and sanctions from the public authorities. So this is really a way to, and the time to cover the subject. More precisely, what are we talking about today? So, as I indicated, transparency is a way to strengthen the application of the principle of equal pay for equal work and equal value. And of course, between men and women. As always, if you have participated to our previous webinar, you know that we try to address the legislation and the landscape, the legal landscape, through a case study, rather than making a catalog of applicable laws. So we will be in a position where you are the Chief Human Resources for EMEA in an international group, and the board wants you to present a strategic plan for the group to be compliant with its transparency obligations. So what will you say or do? We will have our presenters to try to answer these questions. So we have Janina from Luther for Germany, Mauro from Pirola for Italy, Elizabeth and Anna for Austria, Caroline and Alex from Fidal France, and Alex will immediately start to introduce on how to ensure transparency before hiring. So Alex, the floor is yours. Thank you, everyone.
Thank you very much, Antoine. Hi, everybody. My name is Alex Combe. I'm a partner at Fidal, based in Toulouse, and I'm delighted to follow up on the recruitment topic. I will start, as indicated by Antoine, from the following assumption. As Chief HR EMEA, my role today is to present to the board what you need to do concretely to comply with your new obligation before you even hire someone. Because pay transparency starts at the recruitment stage. The directive imposed 3 clear obligations on you as an employer. First, no more salary historic question. You are not prohibited from asking candidates about their current or past compensation. Concretely, this means removing from your interview guides any questions such as what is your current salary or what were you earning in your last role. These are no illegal. Brief your recruiters and agency accordingly because they often ask this question by reflex. Second, you must proactively inform candidates. Every candidate must receive in written the salary range for the role of the initial salary and the relevant CBA provision. For example, if you are recruiting a senior HR manager in France, your job posting or your first written communication must state something like the role of a gross annual salary between 65k euro and 80k euro, for example. in accordance with the applicable CBA. Today, vague mentions like competitive salary or anything else will no longer be sufficient. Third, timing matters. This information must be included in the job offer itself or provided before or during the interview process, not after and not on request. Proactively, this is very a key point. Keep in mind that if a candidate has to ask you for salary range or initial salary for the role, you are already non-compliant. So what does this mean in practice? I'm proposing 5 immediate actions. The first one is to audit your recruitment process across EMEA. Every touch point, job posting, agency brief, interview guides, offer letters. You will likely find inconsistency across country and business line. For instance, your French entity may already include salary bands due to a local practice, while your German or Spanish operation may not. This is only an example. Start with a gap analysis by country. 2, define and formalize compensation range for every role. This is very important. Without this, you simply cannot comply. And I think that I will recommend you working with your compensation team to build salary bands by job family and level based on market data. These bands need to be documented, validated by management, and reviewed annually. Without clear bands, you cannot communicate them and you cannot defend them if challenged. 3, establish a written, standardized, and more officially recruitment process. Documents exactly what information must be communicated at what stage and in what format. For example, salary range included in the job posting, CBA reference in the first interview invitation, both confirmed in the written offer. Make this a checklist your team can follow consistently across all EMEA countries. 4, train everyone involved in hiring. This is not just an HR topic. Line manager conduct interview, and they need to know. They cannot ask, "What did you earn before?" But they can ask, "Does this salary range suits you? Is okay for you?" I think that it is important to run short practical training session, maybe about 30 minutes, focused on what to say, what not to say, and how to handle candidates who voluntarily disclose their current salary. 5, control your external distribution channels. Every job board, every LinkedIn posting, every brief sent to headhunter must include the initial salary or initial salary range, and assign someone to monitor this systematically. It is more prudent. A non-compliant job posting is visible to everyone, and including your employee and regulators. So to summarize, pay transparency is not longer optional. It's a legal requirement, and non-compliance exposes you to legal risk and reputational damage as an employer. And beyond compliance, I think that there is a real opportunity here. Companies that embrace pay transparency tend to attract better candidates, reduce salary negotiation friction, and build stronger trust with their workforce. I recommended you launch a dedicated working group immediately, HR, legal, and communication, with a clear action plan and realistic timeline ahead of national transposition deadlines. I finished my subject, and I think I will now hand over to Janina from Lita, who will speak about the pay transparency, not before, but during the employment relationship. Over to you, Janina.
Thank you. Hello, everybody. My name is Janina Ott. I work at Lotte Law Firm as a senior associate, and together with my colleague Sophia from Max, I will present part 2 today. So we've just heard about how the Pay Transparency Directive shapes the hiring process, what employers need to disclose before someone even walks through the door. That's already quite a shift in how companies need to think about pay, but the directive doesn't stop there. Once someone is employed, the obligations continue, and in some ways they get even more demanding because now we're talking about real ongoing relationships between employers and their workforce. And that's exactly what part 2 is about, how to ensure transparency during employment. And specifically, what do Articles 6 and 7 of the directive require? So let's start with Article 6. The core idea is this: employers must not only pay workers fairly, they must be able to show that they do. And for that, you need clear, transparent, and above all, gender-neutral criteria for determining pay levels, and pay progression. So Article 6 essentially asks employers to sit down and answer a fundamental question: on what basis do we pay people what we pay them? And once you have the answer to this, you can't just keep it in a drawer, because Article 6 requires that these criteria are made easily accessible and visible to workers. So what does that mean in practice? It means workers need to be able to find this information without having to ask for special permission and without having to go through HR. It should be available, for example, in an internal portal, in onboarding materials, wherever it makes sense for the organization. But it has to be there and it has to be findable. There's one exception in the directive. Employers with fewer than 50 employees may be exempted from the obligation to document and communicate pay progression criteria, depending on how member states will implement the directive. Antoine, you can move to the next slide, please. Thanks. So let's move to Article 7. The provision employees will feel most directly in their daily working life, and therefore it is all the more important for employers to know it. So Article 7 establishes a right to request information for workers. Specifically, employees have now the right to request and receive, first of all, information about their individual pay levels, so their own salary, and second, information about the average pay levels for workers doing the same work of equal value, or work of equal value broken down by sex. And this is the key comparative element. It reveals whether a gender dimension exists. It sounds simple, but the interesting question is, what exactly does pay mean? And my colleague Sophia has been thinking about this, and I'd like to hand over to her now.
Thank you very much. And my name is Sophia Petersen, Head of Employment Law at Max Law Firm in Sweden. And I just want to point out 3 practical challenges that stands out with respect to the transparency towards employees. And the first is actually the definition of pay, and that's meaning precisely what to include when communicating pay data requires careful legal and HR alignment, because the directive's definition of pay is exceptionally broad. It goes well beyond base salary to include all forms of remuneration, whether fixed or variable, cash or in kind, and evaluating certain non-monetary benefits present a significant practical burden for companies and remain one of the biggest implementation concerns across member states. And of course, we hope national transition will ease this burden, but so far no local bills have really reflected this pay definition. And then another challenge is the job architecture. Responding meaningful to employee requests demands a robust, up-to-date system for defining and comparing roles of equal value. And many organizations lack this today, and building is, of course, complex, but will be needed in order to be compliant. And the third thing I wanted to lift is the GDPR, because in small job categories, sharing average pay data risks risks identifying individuals, creating genuine tension between both the transparency obligations and data protection requirements. So many different practical aspects of the transparency part not yet solved, and partly why most jurisdictions have postponed implementation of the directive, I believe. Thank you.
Thank you, Sophia. Now, how does Article 7 work procedurally? Employees submit a request through the workers' representatives or through an equality body, and employers must respond within a reasonable time frame. The directive sets a maximum of 2 months here. Also, the information must be provided in writing. And in addition, employers have to inform the employees about their right to request information and also how it works, how to request it on an annual basis. An important final point regarding Article 7, because the directive is clear about this, employers cannot penalize workers for requesting this information or for sharing their own pay data with colleagues. However, employees may be required to treat information as confidential if it does not relate to their own salary. So back to our case study from the beginning, me as the Chief HR Officer would present a 4-step plan to the board. Step 1, map pay structures across all EMEA jurisdictions, identify undocumented criteria, informal pay bands and existing gender pay gaps. You cannot communicate transparently what you have not first measured. Step 2, document gender-neutral criteria for pay and pay progression. Make them easily accessible to employees in each entity, for example, via intranet, onboarding materials, or employment documentation. Step 3, define ownership for handling pay information requests. The 2-month deadline is tight if payroll data is incomplete. Check the employment contracts for confidentiality clauses. And step 4, an important board message on Article 157 TFEU. As we all know, the transposition deadline is the 7th of June 2026, but a missed deadline is not in safe harbor because it could be that national courts derive a right to request information directly from Article 157 TFEU, as we heard the primary law principle of equal pay for equal work, which has direct effect. So even small entities are not automatically protected because Article 157 has no thresholds. So the message really is better act now and be transparent across all group entities. Thank you, and I hand over to my colleague, Caroline.
Thank you very much, Janina, for your overview of how to ensure transparency during employment. Now let's move on the question of how to build relevant categories of employees for transparency purposes. First of all, I'd like to introduce myself. I'm Caroline Ferté, partner from FIDAL in Paris La Défense. And in our case study, I'm speaking as the Human Resources Director. In our strategic plan, job categorization is the key point. I will explain how to manage these. The starting point is Article 4 of the directive. Member states shall take the necessary measures to ensure that employers have best structures in place, ensuring equal pay for equal work or work of equal value. In order to apply this principle, you need to make comparisons, and to do that, you need categories. So let me present the 3 steps. Step 1 concerns job evaluation based on objective and gender-neutral criteria. So the first obligation is to evaluate the jobs with at least 4 criteria: skills, effort, responsibility, working conditions. Secondly, non-technical skills, what we call soft skills, must not be undervalued. Why does that matter? Think of jobs in care, social work, or customer service. Active listening, emotional intelligence, conflict resolution, these have historically been treated as personal qualities, not professional competencies. The result? Jobs mostly held by women were systematically undervalued. That's exactly what the directive is designed designed to correct. One point where workers' representatives exist, the evaluation criteria must be agreed with them. Such job evaluation represents a genuine shift in how companies define the value of work. Step 2 concerns the categorization. Once jobs have been evaluated, workers performing equal work or work of equal value must be grouped into categories. This sounds straightforward. It is not. The categories you create will directly impact the pay gap figures you report. Indeed, categories that are too broad will mask real disparities. On the other hand, if the categories are too narrow, reporting will be meaningless. This is not just a technical detail, it's a strategic and legal decision. And once again, where workers' representatives exist, the categories must be agreed with them. For example, in France, the draft transposition law requires a company-level agreement to be negotiated first. If that fails, a sector-wide agreement can apply. Only as a last resort can the employer act unilaterally after consulting the Works Council, and then the decision of the employer is then valid for 3 years only. Another one practical threshold to bear in mind is that the directive protects the confidentiality of pay data, and in most member states, a category with fewer than 10 workers will fall below the minimum size for individual pay information rights to apply. So you see that size matters. Step 3 deals with pay gap reporting. Once the categories have been defined, the next step is to calculate the gender pay gap within each category. Any existing gaps should then be justified on the basis of seniority, performance, geography, or other objective factors. If gaps cannot be justified, corrective measures should be implemented. Let's move to the next slide, please. Antoine. Okay, now we have the question of the categorization to get the right categorization. And the calibration challenge of the categories outlines the question of the methodology. One thing that doesn't get enough attention is that Article 9 of the directive requires member states to make analytical tools and methodologies available for job evaluation. However, in practice, several transposition laws, including France's, do not yet provide a specific methodology. Guidance from governments or social partners is therefore still needed. For instance, regarding criteria weighting, I'll hand over to my colleague Raphael.
Thank you very much, Caroline. My name is Raphael Schindler. Good afternoon, everyone. I'm a partner at Lutin and the Luxembourg office. Just a very quick word about indeed the weight of the criteria, and which also ties back to the definition of the criteria themselves and to the first step that you mentioned and explained, Caroline. Something that's important to note is that the directive does not say that all the criteria that you use should necessarily be all equal, meaning just if you stick with the 4 mandatory criteria that are defined by the directive, meaning the skills, the efforts, and the working conditions, basically you could very simply consider that all of these 4 criteria are equal and that they all have the same weight, meaning each is worth 25% because there are 4 criteria. But you could also not do so, and you could also consider that they are not equal. And for example, that skills and efforts are worth both 30%, so a little bit more, and that responsibility and working conditions are worth 20% and 20%, so a little bit less. So that opens, of course, a lot of possibilities and a lot of yes, possibilities to do something very tailor-made based on your business. Thank you very much, Caroline.
Thank you, Raphael. So my recommendation for 2026 are start the job mapping exercise now. Take an inventory of your roles, update job description, identify where soft skills are required but not yet formally recognized. Then run a dry run exercise. Apply your proposed categories to your current payroll data, calculate the gaps, see where you stand before those numbers become public. Identify any gaps that you cannot yet justify, address this now, not in 2027. Document every choice. Why did you group these roles together? Why did you keep others separate? This documentation is your legal protection if categories are challenged. Engage with social partners early. In most member states, negotiation is the preferred or required path. And to conclude, categorization is not a spreadsheet exercise. It's not just a box to tick. It's a decision about how your company defines the value of work, and this decision will be scrutinized. When done well, it creates the condition for real pay equity and a defensible compliance position. If done poorly, however, it either conceals or creates artificial inequalities. Neither is sustainable. So the directive provides us with a common European framework. It's up to each company to build on that framework. And it is here that legal advice, social dialogue, and management commitment can make a real difference. I will now hand over to Mauro, who will address equal treatment and the risk of discrimination.
Caroline and Mauro, before Mauro, you take the floor, we just have an interesting question from Sven. What if the company has 50 or more workforce, but several small teams, for example, 3 to 7 persons? According to this comment, disclosing pay would immediately lead to individual salaries being public inside the team. So how can a company address this issue the best? So, of course, we cannot answer all the questions, and it will depend on the legislation that will be transposed in each state member. But we believe one way to address this would be to mix teams and to make categories that are not that are mixing people for the same job or same job category. Of course, in France, we may have an exception when the teams are equal value positions would lead to knowing individual salaries. But clearly, the transparency shall not lead to know individual salaries for each people across the company. So normally, there would be few exceptions. So wait for the legislation, at least for France. Sorry to interrupt.
Thank you, Antoine. It's yours, Mauro, now.
Hello. Good afternoon, everyone. Let me introduce myself. I am Mauro Papais, employment lawyer at Pirola Penuto Zei Associati, based in Milan, Italy. And I will introduce part 4 about equal treatment and discrimination risks. So far, we went through criteria and practical systems to assess transparency and identify possible pay gaps within our organization. I would like to focus now on a practical question. Once pay transparency reveals a pay gap after data are disclosed, when does that gap become a discrimination risk for the employer? But let's start again from the case study we made at first. I act as a chief HR EMEA of an international group, and the board asked me for a strategic plan to comply with the Pay Transparency Directive. And what I would say, that this is not only about disclosing pay information, it's about being prepared and able to defend pay gap once they become visible. That's the real equal treatment issue. Because as we see in this slide, not every pay gap is automatically unlawful. Different pays, different salaries may be legitimate, but they have to be duly justified. Once transparency reveals the difference, the key question becomes very, very simple. Can the company explain that difference by reference to some objective and gender-neutral criteria? So for an HR, acting like an HR, pay transparency is not just a reporting exercise. It's a stress test of whether the pay system is fair, coherent, and defensible. We can now move to the next slide.
And maybe, Mauro, before we move to the next slide, we have a few questions about thresholds and the way to approach ranges across different jurisdictions. So maybe we can try to answer those 2 or 3 questions at the same time. So one question is about the 50 employees threshold. Could you please clarify whether this threshold is assessed at group level across all EU entities or separately at the level of each country or each legal entity at this stage? And again, this is subject to local national legislation. But generally for France, the threshold is assessed at the level of the company, so the legal entity, and there might be some additional obligations for group of companies or a group of companies at EU level. But I believe at this stage, the burden would only apply to companies hiring, so legal entities hiring more than or at least 50 employees. With respect to different jurisdiction, again, we believe that the correspondence and the categories shall be made at the level of one country, not comparatively from one country to another, but this might be the next step in 10, 20, or 100 years. Who knows? Sorry to interrupt, Mauro.
Thank you, Antoine. These were interesting questions because also I would have touched this point in part in this presentation, but I can already say that under a discrimination, from a discrimination point of view, we will see that the comparison between the average treatments and the individual treatment can be made at a group level in specific cases. Let's say, for instance, when the decision to define certain gradings, rankings for employees are taken centrally. So, and in my personal experience, I already saw that larger groups operating in many countries in the world, not only in Europe, are preparing some really complex grading systems to be prepared to ensure justification to pay gaps that exists across Europe and across all the world. So we can start again from the second slide. As the second point I would like to discuss with you is that discrimination is not always clear and evident. Of course, we have direct discrimination, which should not even exist. But in practice, the more difficult risk is often indirect discrimination, because this could arise from a rule that apparently looks neutral, but creates anyways some unequal effects. Let me make a simple example. Imagine a company that gives bonus, for instance, based on the number of business trips performed by commercial officers. On the paper, this rule applies to everyone. It seems okay, but the company does business with a certain country, let's say Middle East, where de facto, in practice, women are not treated as commercial counterparts, are not considered at the same level, the same way as men. And as a result, only men are sent to make deals in these countries, and then they only perform these business trips. There are the base element to calculate their variable salary. So only men can realistically access the related bonus opportunity. So the rule is neutral in form, but not in effect. And this is exactly the kind of situation an HR should analyze and manage as potential indirect pay discrimination. So the real question to take in mind, to keep in mind is the rule formally the same from everyone? This is not the question. The real one is, does the rule reward something that one group can access and another group cannot, for reason linked to and some kind of discrimination, first of all sex, but also all the so-called protected categories, protected by anti-discrimination regulation. So the same, if the answer to that question is yes, if there any discrimination below pay reward systems, the pay driver may need to change. The company may need to reward results, accounts developed, business generated, and not the number of trips itself. This was just an example, but I think it's useful to understand the aim of the directive. And the same logic applies really more broadly. Equal treatment is not limited to the identical job titles. We cannot compare only existing employees who sits the one beside the other. We have the concept of work of equal value, which shall be accessed through criteria set out by the directive. Our colleagues already talked in detail about that, about skills, effort, responsibility, and working condition, but also through even more detailed ranking criteria that can be established within the company let's say, in a tailored way, or even better, agreed with unions, which would be an advisable option, in my opinion, as it would protect even more the company from any possible challenge based on pay gaps. Acting as an HR, I should ask, are we really valuing roles in a gender-neutral way, or are we under-evaluating some specific role, for instance, female-dominated roles? Let me say, in Italy, this is especially relevant in some specific sectors: care, education, back office support, retail, or cleaning system. And this work might be essential, but still structurally undervalued. Can you, Antoine, move on to the next slide, please? Okay, so let's get to the final part, and which is basically based on the risk of claims, which we might say become more way easier to build. But why? Basically because employees will see more, they will have more information, and patterns to determine salaries will be easier to identify. And also some statistic criteria can be used. And now we're coming back to the questions some participants made, because pay inequalities can be part of a broader discrimination claim. As you can see in this slide, we have multiple factors that can be used to ground a claim based on discrimination. We already said we don't have to, the comparison is not limited to a single comparator, which means an employee who existing and working beside us. But the comparison is way broader. So we can also consider, the employee can consider a comparison across different entities of the group, some other employees working for some parent companies. Of course, if the salary is set centrally, so from the same, let's say, HR office. We also have a temporal flexibility. We can consider a comparison with a former employee, Of course, it shall not be someone who was working in the same company 10 or 15 years ago. So the comparison must be reasonable. But if there is no specific comparator, the employee can even use some statistics or sector, meteorological sectors statistics, or even hypothetical comparators, which you can understand this broadens the scope of the possible comparison. And moreover, in terms of discrimination, consider that unequal pay may later be used together with some other facts that affect maybe not directly the salary, but the level and the position of the employee, such a lack of promotion, poorer treatment after maternity or parental leaves, or reduced access to variable compensation, just as like in the example I made before, to support a wider allegation of discrimination, which might have an effect on different kind of claims. For instance, a claim against a dismissal, which in all Europe and in Italy as well, would result in a way stronger protection of the employee. And also, this is because when an employee makes an allegation of a discrimination clue, which in our case can be also revealed by some unjustified pay gaps, these lead to reverse the burden of proof. So this forces the employer to provide evidence that no discrimination is or was in place in that specific situation. So it's quite easy for an employee to use pay gaps element to ground a wider discrimination claim. So coming to the end and coming back on the case studies question, what will I say or do to the stakeholder within the company about a strategic plan about pay transparency? My answer would be, we need a plan that identifies unexplained pay gaps, test whether pay drivers are genuinely gender neutral, reviews whether female-dominated roles are undervalued, and then document objective justification before any complaints arise. And in my opinion, I agree with all my colleagues that already said that before. This activity shall be done as soon as possible, regardless to the fact that most part of EU states, member states, are not drafting any local measure, as in Italy we already have, even if there's still some doubts about the application. Because in any case, courts, in case of claim, could directly apply the directive or interpret local laws in conformity to EU ones. So thank you very much for your attention, and I'll now leave the floor to Elizabeth for the next section about sanctions. Many thanks.
Thank you, Mauro. My name is Elisabeth Plescher. I'm an attorney at KWR based in Vienna, Austria. And thank you to all the previous speakers who already discussed the new obligations under the Transparency Directive. In the next section, we will take a look at the duties and sanctions in case of violations against these obligations. So on the first slide, let's continue with our case study company, and imagine they, as an international group, have a few companies in different member states, and in at least one member state we have more than 250 employees, so the reporting obligations apply to the company in this member state. If in our case study company publishes their Article 9 pay report, and it shows, for example, a 6% pay difference gap in a specific category, let's say marketing or sales, and they cannot justify it on objective criteria, and also 6 months pass, nothing changes in this situation, that's the moment the directive or the respective law steps in and says, you now have to conduct a joint pay assessment together with your workers' representatives, which could be the Works Council. And take a look at the right side of the slide. That's what the assessment has to cover. In the joint pay assessment, the company and the workers' representatives have especially the following duties: breaking down pay by gender and per category, explaining every gap, tracking what happens to pay after parental leaves, and committing to concrete measures and evaluating if they work. Maybe member states will add to this list, but for now, that's an example of duties they have to follow. On the next slide, we have to ask what rights and enforcement mechanism does the protective directive provide. Let's also start with an example. For example, Jo, an employee, discovers that she's been earning 8% less than a male colleague in the same role, and that for several years. After bringing a claim, the company may have to repay the salary difference retroactively for all the years where it was not at the right pay, compensate her for missed annual bonuses, and also cover damages for stress or distress caused by the discrimination. So it's a huge thing if you don't try to make the groups right and classify people in the correct areas with the right criteria. Another example could be a female manager who was consistently overlooked for promotion because of discriminatory pay practices. In that case, compensation could also include the financial loss linked to missed promotion opportunity. And also please note that there is a real shift, which Mauro mentioned before, the reversal of burden of proof. The company cannot wait for Jo or the female manager to prove the discrimination. You as a company have to prove that there wasn't any. So it's really important to have documentation on every aspect of the pay and of the to have the transparency for it. And on top of individual claims, authorities could also step in directly by ordering the company to stop the infringement, monitor compliance, and even issue penalty payments. On the next slide, we will see other sanctions. What happens when companies don't comply? Member states have to put into place penalties that are effective, proportionate, and dissuasive. This could mean recurring fine for every month they remain non-compliant, direct compensation payments to affected employees, and escalating penalties if it's not the first violation. For example, if the company repeatedly fails to publish the pay gap report or refuses to carry out required joint pay assessments, national authorities could impose increasing monthly fines and the company has to comply with them. Another example could involve the company participating in public tenders. If serious violations are identified, the company may lose access to existing public contracts. They could be terminated, and they could also be excluded from future public procurement procedures. And for many companies, that's not just a HR risk for claims for employees, that's really an existential business risk if you're losing public contracts. So the message I want you to take away from this section is that non-compliance will always cost more than compliance. And for an overview on the tips and traps and how to do it, I will now hand over to my colleague, Anna.
Thank you very much, Elisabeth, and thanks to all my previous speakers. I think you got a lot of valuable insights from Alix from France on how to ensure transparency before hiring, from Janina on how to ensure transparency during employment, together with very important tips from Sophia from Sweden. Also on very concretely how to build relevant categories of employees for transparency purposes, which is one of the key issues from Caroline from France, on all the discrimination aspects from Mauro from Italy, and then also it is very important to know the duties and sanctions in case of violations from Elisabeth. So as you see, and going back to our case at the beginning, what will you say or do as a Chief Human Resources EMEA after having heard this webinar? You would probably say, oh no, I'm really late because there's a lot to do. So let's get started. And I think that organizations that have already started or right now start with doing all what you've heard, They will reduce risk, they will strengthen trust, attract stronger talent, and differentiate themselves. It's not only about creating paper. Documentation is really important in all what you've heard. And I really want to emphasize that you need to do this, you need to create paper, you need to do documentation, but it's more. Transparency, pay transparency is also a chance. It's about creating clarity, accountability, and confidence. And it's also about really being transparent, because the market and the world is being more transparent. So in the last few minutes, I want to give you some takeaways of what you should definitely do and what you should definitely not do, summarizing what my previous speakers already outlined. Please use transparency as a structured, well-managed process. It's not something that one person can do overnight. It's a process. You need FTEs, you need clear definitions on who is competent for what. You have to make a decision on whether you do it purely internally, on whether you engage advisors, and also about which advisors you take on board. Of course, there are lots of advisors out on the market. Please make sure that you choose the right one and that you choose a professional one. We have seen processes like this really not working well because of not proper external advisors. It's really important to assess and refine existing compensation frameworks. Hopefully you already have compensation frameworks. So those companies who already have compensation frameworks do have an advantage right now, because they can build on something, whereas a lot of companies don't even have compensation frameworks. So they should really try to have them now. It's very important to document each and any objective justifications. So if you want to step outside of the framework, make sure that you have objective justifications. Plan ahead for reporting and disclosure requirements. Today and also in June, probably no authority will come to you and say, give me everything. But eventually they will come. And even if they don't come from themselves, there will be competitors, there will be granted employees. You never know who will file a claim or a query to have more information on what you do in order to comply with the directive. So also implement clear and consistent pay structures. Unless you have already done this, then it's easier for you, because then it's more a refining and reviewing. And equip HR teams and managers with training, because this is not easy. This is not what you can learn in one webinar. So it's very important to make trainings for especially HR teams and also the managers. And if we now, in the last 2 minutes, jump towards the don'ts. As said, and I have to say it one last time, don't wait. We don't know when which country will do their own laws, and I think it's also not so important, because a lot of things are clear duties from the directive. So make sure that you comply with them. Don't underestimate the scope of what you have to do. So it really is worthwhile having a project team, not just one person. Think about who will be in this project team and with which measures they will be equipped. And don't treat it as a one-off exercise. It is a learning for all of us, also for us lawyers. So be sure that you consistently revise the process. And don't focus on the figures, on the numbers. Really go beyond. Check the structures, check your culture, and make sure that you also treat this as a possibility to get more visibility on the market. It's a competitive advantage to be transparent. It can also attract talents. So also in the war for talents and as regards employer branding, transparency, compliance is really important. Especially the younger generation is asking for transparency. They request equal treatment. So also from this regard, it's very important. Don't request or rely on candidates' salary history. That has been like this in the past, but it's even more important now. And to stop here, don't ignore the potential reputational impact. It's not only about fines, It's about more. It's about your way, how you pose yourself on your company on the market. And with this, back to Antoine for the final remarks.
So thank you very much. We are close to the end because we are 4 o'clock. We still have a few unanswered questions from the audience. So just coming back on the thresholds, as we have a questions on the 50 employees threshold, please note that we do have exceptions for transparency and pay progression policies. Okay, but generally speaking, and this will be of course subject to applicable local legislation, most of the directive should apply to all employers and all size of companies. We just have a few obligations that could be exceptions for employers hiring less than 50 employees. And there is also thresholds that apply to pay gap reports. So you will have various dates to implement the reporting pay gap obligation. If you are employing less or fewer than 100 employees, between 100 and 150, etc., etc. But generally speaking, when you are hiring employees, transparency should apply. You should publish a range of salary, etc., etc. So it involves and concerns everyone. We also have a question on EOR employees and thresholds. I will summarize it this way. Shall you count external workers in the threshold of employees? This will be a question for your local legislation, but generally speaking for France, we do have an obligation to take into account external employees that are made available on site for more than 1 year. So generally speaking, you will count external providers, including EOR employees, if they are made available on site for more than 1 year. I do hope we've covered all the questions, but I assume you may have additional questions. So feel free to contact the speakers and local representative. You have an impressive list of names and people here. Not all of them were participating to this webinar today, but please be ensured that we are used to working together and that you may raise a question to one member of our team and we will circulate that to the others. So feel free to address your questions to the attorney you know in the country you know. Thank you for your attention. Hope to see you soon at our next webinar, or if you have a case. Thank you, everyone.
Thank you.